Good morning. The Subcommittee on Government Management Organization and Procurement of the Committee on Oversight and Government Reform will now come to order. Today's hearing will focus on the federal government's role and responsibility in the global protection and enforcement of intellectual property rights. The subcommittee will also seek additional information from administrative witnesses on the strategic objectives of the Obama administration for improving coordination among the stakeholder agencies having IPR protection or enforcement responsibilities. Without objection, the chair and ranking minority member will have 5 minutes to make opening statements, followed by opening statements not to exceed 3 minutes by any other member who seeks recognition. Without objection, members and witnesses may have 5 legislative days to submit a written statement or extraneous materials for the record. I'd like to welcome all of you to today's subcommittee hearing on federal efforts to protect and enforce the intellectual property rights of our nation's industrial base throughout the domestic and global marketplace. Before we begin, I'd like to apologize for the subcommittee having to postpone our original hearing that was scheduled for November 4th, but our legislative calendar was rather full that week, as some of you probably will recall. So I welcome our distinguished witnesses, especially those who have had to rearrange their travel or business schedules in order to attend today's rescheduled hearing, and look forward to hearing your testimony. Intellectual property rights, or IPR, is an issue that is near and dear to my heart and the livelihood of many of my constituents. My congressional district, the 33rd, which includes Los Angeles, Culver City, and Hollywood, California, is home to a number of important entertainment companies, including Sony Studios, the Culver Studios, Capitol Records, Raleigh Studios, and television studios, and of course the American Film Institute. According to figures compiled by Americans for the Arts, approximately 30,000 people are employed in entertainment-related industries located in my congressional district. More than 18,000 people who work in the congressional district make a living from film, radio, and television, whose profits and future viability are dependent on strong IPR protection and enforcement. As a fellow member of the California Congressional Delegation, I know my ranking member, Bill Bray, recognizes the vital economic importance of intellectual property to our state's economic health, as well as to the future growth and stability of our nation and the global economy. Since the establishment of the World Trade Organization in 1995, America's key IP-related industries have prospered through our domestic comparative advantage in innovation and research. But this advantage has been severely undermined by sharp escalation in IP infringement, such as piracy and counterfeiting, even among our closest and most vital trading partners and strategic allies. This causes great economic harm to innovations and innovators who invest significant capital in the products or creations that have improved our standard of living and increased our knowledge base. While the true amount is unclear, recent estimates of the losses or cost associated with IP infringement for the U.S. domestic industry ranges from $200 to $250 billion annually. The prevalence of such losses extends to all IP-related sectors, including information technology, life sciences, digital content, pharmaceuticals, the defense industry, and the entertainment industry. These losses threaten our nation's economic growth and global leadership in innovation. Furthermore, IPR infringement poses significant risk to our national security, consumer welfare, and ability to rely upon an effective legal framework for our domestic industries working abroad. According to the Los Angeles County Economic Development Corporation, the cost of global privacy and counterfeiting activities in Los Angeles County in the year 2005 was estimated at $5.2 billion. Those figures were proportionally shared across all sectors of the IP-driven economy, with motion pictures leading the way at $2.7 billion, followed by the recording industry, apparel makers, and software developers. Unless such trends are soon curtailed, the roughly 1 million LA County IP-dependent jobs will be placed at a significant risk. The findings in this year's special 301 report issued by the Office of U.S. Trade Representatives tell us that a combination of technological advances and various market access barriers in key countries are preventing our companies from protecting their IP-based goods and services. So with that in mind, I would like our witnesses to discuss what they believe are the major factors in the escalation of IPR infringement abroad. Specifically, I want our government panelists to explain how they believe the newly established Intellectual Property Enforcement Coordination Office will aid in their development of a stronger framework for managing our interagency IPR protection and enforcement responsibilities, both domestically and abroad. Specifically, with new authorities, and what new authorities has this office been granted to police our patchwork of agencies charged with combating global IPR infringement? Furthermore, I'd like you to discuss how our trade agreements with other nations, including those issues being negotiated as part of the proposed anti-counterfeiting trade agreement, are reducing the growing incident of digital-based piracy or the illegal manufacturing of counterfeit drugs and consumer goods for importation. These activities pose significant threats to our economy, to public health, to national security, and must be countered in order to maintain our position in the global marketplace. And lastly, I'd like to address an emerging IPR issue with the People's Republic of China and its efforts to restrict our domestic technology industries from participating in their government-wide procurement programs. And under the Chinese government's newly issued rules, only products that contain Chinese proprietary intellectual property would be eligible for government procurement. This process will, in effect, result in excluding the products of international companies from the government procurement market in China. This is a troubling development that will have major economic consequences for our trade relations if we do not find an amicable resolution. And I am hopeful that our witnesses can educate us on the latest developments with these matters and other recommendations on how we at the subcommittee can be helpful in facilitating a resolution for all parties involved. I'll also ask my ranking member, Mr. Bilbray, for his consideration on how we may be able to work collaboratively on this topic of vital importance to our home state's economy. Once again, I want to thank our panelists for joining us today and look forward to your testimony. And with that, are you taking the place, Mr. Issa? Yeah, our distinguished member, Mr. Issa from San Diego, will take the place of our ranking member, Mr. Bilbray.
Thank you, Madam
Mr.
Chair.
Issa.
And I'd ask unanimous consent that Mr. Bilbray's entire opening statement be placed in the record.
Without objection.
Thank you, Madam Chair. Intellectual property contributes $5.5 trillion. I repeat, $5.5 trillion a year to our economy. In fact, we have become the intellectual property giant around the world. We have traded many, many jobs, entry-level jobs in manufacturing of garments and other products for our development of these high-skill, high-paying jobs, and we've offloaded many of them to China. So I find it today particularly confusing that China would look at this bargain that has been so favorable to them and begin the process of far exceeding any moratorium or prohibition allowed under the WTO. We in the United States Congress, under the chairwoman and my watch, participated in China ascending to the WTO. They did so not having met all the requirements, but with a promise to meet them and to continue in this direction. Intellectual property was, in fact, at the core of the items which China had not lived up to their responsibility but promised to. Over the years, countries such as Russia have been prohibited and stopped from getting into that for a good reason. We've seen that China has not gained any respect for intellectual property. In fact, they continue to be the largest customer in Asia for Microsoft products. They simply don't buy them. Madam Chair, it's very clear that we have to say that China has a right to have such special property as is necessary for its own defense. We, too, maintain a policy that certain technology must be domestic for our national security. Certainly neither one of us would want the ability to put a space-based defense system into space not to be domestic and domestically controllable and known. But China very clearly is trying to force partnering with U.S. companies, transfer of technology for purposes of getting a jump start on that next generation of products and services. So, Madam Chair, I appreciate your viewing something which this committee has a long-standing belief that we not only control the procurement process government-wide, but we have, by necessity, a requirement to look beyond our borders for free and fair trade and access for our products. So I look forward to our witnesses, and again, Madam Chair, thank you for holding this important hearing, and I yield back.
Thank you. Without objection, members and witnesses may have 5 legislative days to submit a written statement or extraneous materials for the record. I now yield to Congressman Cuellar for opening statement.
Thank you, Madam Chair. I appreciate this hearing. I'm a big believer in trade agreements, but one of the things that I think, along with my other colleagues, we got to make sure that we protect our intellectual properties. I'm interested, as we go through the testimony, to see what what we're looking at as we look at the countries of Colombia, the countries of Panama, and of course Korea also. If y'all could highlight that also during your testimony, if one of y'all can do that. Otherwise, Madam Chair, I'm ready to listen to the testimony and ask some questions afterwards. Thank you very much for having us here today.
If there are no further opening statements, the subcommittee will now receive testimony from the witnesses before us today, and we'll now turn to our first panel. There'll be two this morning. And it's the policy of the Committee on Oversight and Government Reform to swear in all witnesses before they testify. And I'd like to ask all of you to please stand and raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Okay, let the record reflect that the witnesses answered in the affirmative, and I will now introduce the panelists, and we'll first start with Mr. Stanford K. McCoy, who is the Assistant U.S. Trade Representative for the Intellectual Property and Innovation at the Office of U.S. Trade Representative, and he serves as the Chief Policy Advisor to the United States Trade Representative on the Intellectual Property and Trade Issues, and serves as the lead U.S. Trade Negotiator on Intellectual Property and Innovation to the WTO and TRIPS Council, and as part of the U.S. Free Trade Agreement negotiations. Next to him is Mr. Robert Stoll, who is the Commissioner of Patents at the U.S. Patent and Trademark Office, where he oversees the administration of all USPTO patent programs. And prior to his current appointment, Mr. Stoll served as Director of Enforcement for USPTO, as well as Dean of Education and Training Programs for external agency stakeholders involved with intellectual property issues. Mr. Jason Weinstein is the Deputy Assistant Attorney General of the Criminal Division at the U.S. Department of Justice. Before joining the Criminal Division, Mr. Weinstein served as Chief of the Violent Crime Section in the U.S. Attorney's Office for the District of Maryland and as Assistant U.S. Attorney for the Southern District of New York. Before becoming a federal prosecutor, Mr. Weinstein served as Special Investigative Counsel in the Justice Department's Office of Inspector General. Mr. William Kraft is the Acting Deputy Assistant Secretary of the Bureau of Economics, Energy, and Business Affairs at the U.S. Department of State. Prior to this, he was Director of the Office of Multilateral Trade and Agricultural Affairs. He is the lead officer in the State Department for all issues related to the World Trade Organization, or WTO, including negotiations involving the Doha Development Round and WTO accession issues. And Mr. Lauren Yeager is the Director of International Affairs and Trade at the Government Accountability Office, where he oversees issues associated with intellectual property rights and international trade negotiations. And I ask that each of the witnesses now give a brief summary of their testimony, and to keep this summary under 5 minutes in duration. Your complete written statement will be included in the hearing record. And before we proceed, I'm going to ask Ms. Chu if she would like to make an opening statement.
I'm just happy to take part in these proceedings, and I look forward to hearing what the witnesses have to say.
We're happy to have you. Oh, Mr. McCoy, would you please proceed?
Thank you, Madam Chairwoman. Thank you, Madam Chairwoman. Thank you to the ranking member, Mr. Bilbray, and all the members of the subcommittee for the opportunity to join you today and talk a little bit about the mission of the Office of the U.S. Trade Representative in respect of the protection and enforcement of intellectual property rights. As you said in your opening statement, Madam Chairwoman, one of the factors that makes American exporters and investors competitive across so many sectors of the global economy is the value we add to our products and services through innovation and creativity. Intellectual property rights and their protection and enforcement are critical to securing that comparative advantage in global trade, and thus to securing the jobs of workers in America's many innovative and creative industries. Providing leadership in the creation and maintenance of a global infrastructure of trade rules to support American exports and investments is a critical part of the work of the Office of the U.S. Trade Representative. It's a job that we carry out in coordination with the other agencies represented here at the table and in coordination in coming days with the new Intellectual Property Enforcement Coordinator who's recently been confirmed by the Senate. We carry out that mission in many ways. One of the best tools we have is one that was handed to us by the United States Congress of consistently monitoring our partners' trade practices through the Special 301 report. If they know that we are holding a magnifying glass up to their actions, they will be less likely to break the rules. And Special 301 is one of our biggest and strongest magnifying glasses. We use it to scour the globe for copycats and counterfeiters and call out countries that provide safe havens for the theft of American intellectual property. Madam Chairwoman, this year marks the 20th anniversary of the first Special 301 report, which was mandated by the U.S. Congress in 1988 and first issued in 1989. The past 2 decades have brought enormous new challenges in the scope and sophistication of international piracy and counterfeiting. The Special 301 process has expanded in scope and breadth to match that challenge. For our most recent report, USTR examined IPR protection and enforcement in 77 countries and listed 46 of them in the report. Special 301 works because the report's rankings shine a light on IP protection and enforcement and also afford an opportunity to give credit where it's due. The Republic of Korea is a good example of both of those. It was removed from the watch list in 2009, marking the latest in a series of improvements in the Asia-Pacific region and around the world that have been encouraged and recognized through the Special 301 process created by Congress. We hope to see that trend continue and spread. It is vital that trading partners such as China, Russia, and other countries on the priority watch list and watch list follow suit. It is also critical that valued trading partners like Canada and Spain step up and confront emerging challenges like internet piracy. China still presents significant challenges to the protection and enforcement of intellectual property rights, including the indigenous innovation challenge that was mentioned by you, Madam Chairwoman, and by Mr. Issa in your opening statements. With China, we are making use of every available trade tool to achieve progress on IP issues. Madam Chairwoman, let me say it as plainly as Ambassador Kirk has said it, China must do more to protect U.S. intellectual property rights. In addition to reporting and engaging bilaterally, USTR is also providing essential leadership through trade agreements to strengthen norms for the enforcement of intellectual property rights. A key USTR initiative in this area is the Anti-Counterfeiting Trade Agreement, or ACTA. In that effort, we're partnering with a group of key trading partners representing about 50% of global merchandise trade. When it's finalized, the ACTA will help governments around the world to more effectively combat the proliferation of pirated and counterfeit goods. With that, Madam Chairwoman, I will close my summary of my remarks and thank you and the members of the committee again for the opportunity to be here today.
I thank you, Mr. McCoy, and Mr. Stoll, you may proceed.
Thank you, Madam Chairwoman Watson and members of the subcommittee. I am pleased to be here to discuss the efforts of the Department of Commerce and the USPTO in promoting the protection of intellectual property rights in a global economy. Innovation and creativity are essential ingredients of our nation's prosperity. Appropriate protection of that innovation and creativity, domestically and internationally, is necessary to stimulate job growth and promote our economic well-being. That's why safeguarding these important assets is a top priority for all of us at this table and throughout the Obama administration. It is truly a team effort among our agencies to help fight piracy and counterfeiting within and outside our borders. The Department of Commerce plays an important role in encouraging innovation and strengthening the nation's ability to compete in the global marketplace. The USPTO's statute directs us to advise the President through the Secretary of Commerce on intellectual property issues and to advise other federal departments and agencies on matters of intellectual property policy in the United States and in intellectual property protection in other countries. To this end, we are actively involved with the development of overall U.S. government IP policy. We work to develop unified standards for international IP, provide policy guidance on domestic IP issues, and work with other agencies to secure strong IP provisions in free trade and other international agreements. We also provide training, education, and capacity building programs designed to foster respect for IP and encourage the development of strong IP enforcement regimes by U.S. trading partners. Madam Chair, my written statement contains more details of a wide range of our efforts. In my limited time here, I'd like to highlight some of our programs and initiatives. The USPTO coordinates, organizes, and participates in intellectual property rights training, trade capacity building, and technical assistance. We are especially proud of our Global Intellectual Property Academy, or GIPA. Since its creation in 2005, the USPTO has provided in its 20,000 square foot training facility in Alexandria, Virginia, a high-level capacity building programs and technical assistance training to foreign judges, prosecutors, customs officials, IP enforcement personnel, as well as officials from copyright, trademark, and patent offices from around the world. Those individuals come to the U.S. to learn, discuss, and strategize about global intellectual property rights protection and enforcement. Our program goals include fostering a better understanding of international intellectual property obligations and norms, exposing participants to the U.S. model of protecting and enforcing intellectual property rights, and promoting discussion of intellectual property issues in a friendly and supportive environment. The Academy provides both multilateral programs and country-specific programs as needed. We further envision programs dedicated to specific legal issues or technologies as the Academy continues to develop. The USPTO's programs reached an average of 4,000 individuals in over 100 countries annually. In partnership with the Department of Commerce's U.S. and Foreign Commercial Service and the Department of State, USPTO intellectual property experts are sent out to strengthen global intellectual property protection and enforcement overseas in selected high-profile countries where U.S. IP challenges are greatest. The IP experts support, as part of the Overseas Intellectual Rights Attaché Program, U.S. embassies and consulates on IPR issues, including devising strategies to stop counterfeiting and piracy, and supporting U.S. government efforts to improve the protection and enforcement of IPR. They also advocate U.S. intellectual property policies, coordinate training on IPR matters, and assist U.S. businesses that rely on IPR protection abroad. The USPTO has offered free programs and materials to help small and medium-sized businesses improve their understanding of intellectual property, increase the value of intellectual property in their businesses to protect against counterfeiting and piracies, and of their intellectual property through our public awareness campaign. An important effort is the Intellectual Property Awareness Campaign, IPAC, IP Basics program, offered nationwide by USPTO since 2005 to over 1,000 small and medium-sized businesses. These programs included presentations by our attorney advisors that cover the entire range of intellectual property. And with that, Madam Chairman, I would like to conclude my remarks. Thank you.
Thank you, Mr. Stoll. Mr. Weinberg, you may proceed.
Good morning. I want to thank you, Chairman Watson, and the ranking member and the members of the subcommittee for the opportunity to appear before you today. Attorney General Holder has made intellectual property protection a top priority, and the Department of Justice is fully committed to aggressive, effective criminal enforcement efforts to protect our nation's IP stakeholders and the American public. The Department has worked with our law enforcement partners to develop a strong enforcement program that combines aggressive investigation and prosecution of IP crimes with law enforcement training and victim outreach. However, because we understand that in the global economy, a successful criminal enforcement program requires a strong international component, we also work in partnership with our foreign law enforcement counterparts wherever possible, which has resulted in great successes. For example, in January of this year, Kevin Zhu was sentenced to 78 months in prison for conspiring with others in China to traffic in counterfeit cancer drugs and other pharmaceuticals. Many of these counterfeits were lacking active ingredients or contained unidentified impurities, and drugs with lot numbers identical to the counterfeits were detected in the legitimate supply chain in London, which prompted a massive recall in the UK. Just this past September, the Department obtained its 64th felony conviction arising from Operation Fastlink, which targeted multinational organized criminal networks. In the underlying investigation, which was one of the largest international law enforcement actions ever taken against online piracy, the FBI worked with foreign law enforcement to conduct over 120 simultaneous search warrants in 27 states and a dozen foreign countries. Now, these are just two examples of the many, many successful international enforcement efforts that we have participated in, and we're proud of all of them. And they all demonstrate the value of strong relationships with international and foreign law enforcement. The cornerstone of the Department's international efforts is the Intellectual Property Law Enforcement Coordinator, or IPLEC, program. With the help of the State Department, we have deployed 2 experienced federal prosecutors to serve as IPLECs, one in Southeast Asia and one in Eastern Europe, to provide training and operational assistance in those regions. Working with the IPLEC for Asia, the Department also spearheaded the formation of the Intellectual Property Crimes Enforcement Network, or IPSEN, which has helped to strengthen communication channels and promote the informal exchange of evidence among member nations in Asia. In addition, the Department, through the Criminal Division, co-chairs the Intellectual Property Criminal Enforcement Working Group, which is part of the U.S.-China Joint Liaison Group for Law Enforcement Cooperation. The working group has fostered an open dialogue on criminal IP enforcement, has increased information and evidence sharing, and has resulted in a number of successful joint operations between the U.S. and China, including Operation Summer Solstice, which targeted a criminal organization believed to be responsible for the distribution of over $2 billion worth of pirated and counterfeit software. Summer Solstice was the largest ever joint criminal enforcement operation between the FBI and law enforcement in China. More generally, the Department has placed great emphasis on efforts to strengthen enforcement capacity overseas, from Europe to Asia to Africa to South America to Mexico. In fact, over the past 5 years, working in partnership with some of the agencies represented here on this panel with me, DOJ attorneys have provided training and education on IP enforcement to over 10,000 prosecutors, investigators, and judicial officers from over 100 countries. And because IP crime has increasingly become the province of international organized crime, we're working to identify and to address links between organized crime and intellectual property. And the Department has already taken a number of significant steps to incorporate IP into its existing international organized crime strategy, as directed by the Pro-IP Act. To succeed in the missions that I've outlined, we work closely with all of our partner law enforcement agencies, including through the National Intellectual Property Rights Coordination Center. And our ability to increase the number and scope of our IP investigations has also been bolstered more recently by the addition of 31 dedicated FBI special agents to investigating IP crime, and we appreciate Congress's decision to fund those positions. Finally, the Department works extensively on IP issues with other agencies in the federal government, including those represented here today, and with the industries most affected by IP crime. And we also look forward to working closely with Victoria Espinel, who was confirmed just last week as the new IP Enforcement Coordinator, and with our partner agencies on the newly formed or to-be-formed IPEC Advisory Committee. Again, I thank you for the opportunity to share with you the high priority that the Attorney General places on criminal enforcement of IP rights and the work that we do every day at the Department of Justice to combat intellectual property crime both here and abroad, and I'd be happy to take your questions.
Thank you, Mr. Einstein, and now you may proceed, Mr. Kraft.
Thank you, Chairman Watson, honorable committee members. It is a pleasure to be here today to testify on the State Department's role in protecting intellectual property rights in today's global economy. We welcome the committee's interest in this issue and look forward to continuing to
Can you bring your mic a little closer?
Sorry, ma'am.
I pointed up towards you.
Yeah.
That's it.
I'm suffering from a cold a little bit, I'm afraid. We welcome the committee's interest in this issue and look forward to continuing to work with you to achieve our mutual goal of ensuring that U.S. intellectual property rights are fully respected everywhere in the world. As President Obama has said, innovation is the key to good new jobs for the 21st century. Since intellectual property rights encourage and reward innovation, protecting American intellectual property abroad is one of the State Department's top economic policy priorities. We work closely with other U.S. government agencies, the private sector, and foreign governments to achieve that goal. Within the State Department, our efforts are led by the Office of Intellectual Property Enforcement, part of the Trade Policy and Programs Deputate that I head. That office now has a staff of 12 people. As you are aware, Congress created this office in 2005 to strengthen State Department efforts to combat counterfeiting and piracy. IPE promotes enforcement of U.S. IP rights overseas, represents the State Department in interagency IPR policy discussions, and participates actively in bilateral and multilateral negotiations to improve enforcement of IP rights. State implements IPR enforcement training and technical assistance programs, for which the Congress has given us $4 million in 2009. In calendar year 2009, we used that money to train over 1,500 customs, police, and judicial officials from more than 21 countries, including Ukraine, Mexico, Russia, Vietnam, and Nigeria. State also conducts public outreach to foreign audiences on the importance of IP to host country economies, innovators, and creators, and trains our embassy officers overseas around the world on IP enforcement. Intellectual property enforcement is integrated into the work of other State Department bureaus and offices. For example, we work closely with our Bureau of International Organizations and with other agencies to strengthen the World Intellectual Property Organization and to ensure that other UN agencies support good IP policy. Our regional bureaus, U.S. embassies, and consulates are on the front lines of protecting U.S. IP rights in particular countries, responding to complaints raised by U.S. companies and vigorously pressing foreign governments to combat piracy and counterfeiting. There is a Foreign Service officer assigned to work on intellectual property protection in every U.S. embassy overseas. Madam Chairwoman, as you've noted, piracy and counterfeiting are still enormous problems, but we are making some headway. There are more examples in my written testimony, but let me just cite two examples of areas where we think we've made a concrete impact. On the enforcement side, the U.S. government and the private sector have been working actively with Mexico to encourage them to increase enforcement of their laws. And working on information provided by the U.S. industry, the Mexican Attorney General's office recently arrested a number of individuals for camcording in movie theaters, thereby dismantling one of Mexico's major camcording rings. In terms of the winning hearts and minds side on public outreach, we think an excellent example is the way that our embassy in Bosnia helped to develop an IPR school campaign with a curriculum and comic books printed in the 3 local languages, supported by appearances by the U.S. ambassador and several Bosnian movie and music stars. Let me just note, Madam Chairwoman, that the State Department concurs with the recent GAO report's recommendations on improving coordination between our embassies and our intellectual property attaches overseas, and we have sent a cable to relevant posts instructing them to implement the recommendations of the GAO. We are getting responses from the posts, and we're reviewing those now. As Mr. Stoll and some of the others have noted, we know very well and very favorably Ms. Espinel, and we look forward to working with her as she tries to raise the image and profile of protecting intellectual property as she takes on her new role, and we look forward to working very closely with her. So finally, let me just thank you and the committee for your interest in this very important issue and to assure you that we look forward to working with you to strengthen our efforts to protect intellectual property. Thank you, Madam Chairman.
Thank you, Mr. Kraft, and now you may proceed, Mr. Yeager.
Thank you. Good morning, Madam Chairwoman, Ranking Member Bilbray, members of the subcommittee. Thank you for the opportunity to appear before the subcommittee to discuss our work on U.S. efforts to protect intellectual property rights. We appreciate the opportunity to continue our contributions to the record that this committee has established on IP protection. This hearing is timely as Congress recently overhauled the U.S. structure for IP protection. The Pro-IP Act created a new structure, and the Senate recently confirmed the coordinator to chair the new advisory committee. In my statement today, I will address two topics on IP protection and enforcement that are relevant to that new structure. First, let me talk about the lessons learned from past efforts to coordinate IP protection and enforcement. And second, I'll make a few observations on the efforts of the Patent and Trademark Office intellectual property attachés in key countries around the world. Let me start with a few observations from our prior work. The Pro-IP Act of 2008 enacted several changes that address weaknesses we found in the prior IP coordinating structure. That structure was initiated under two different authorities and lacked clear leadership and permanence, hampering the effectiveness and long-term viability of such coordination. In a GAO report undertaken for this committee in 2004, we reported that this council had not undertaken any independent activities since it was created. Congress subsequently made enhancements in 2004 to strengthen its role, but we reported that it continued to have leadership challenges. In contrast, the presidential initiative called STOP had a positive image among the agencies and the private sector, and from its beginning was characterized by a high level of coordination and visibility. However, as a presidential initiative, it lacked permanence, since its influence was tied to a single administration. While its impact will depend upon its implementation, the Pro-IP Act of 2008 enacted several changes that address weaknesses in that prior structure. For example, the Act places leadership in the Executive Office of the President, a status similar to STOP. In addition, the Pro-IP Act specifically requires the new agency to prepare a strategic plan that builds in mechanisms for accountability and for oversight. The Pro-IP Act requires the Council to submit the strategic plan to committees of the Congress to improve accountability. Let me now turn to another important issue, and that is the placement of PTO IP attachés abroad. An additional theme of the Pro-IP Act is the emphasis on strengthening the capacity of U.S. agencies abroad to protect and enforce IP rights. In a report we released in September of this year, we found that the IP attachés could be an asset to U.S. firms and to other U.S. agencies who needed assistance in matters related to IP enforcement. These IP attachés provided this assistance by adopting a number of practices. First, the attachés served as effective focal points. Prior to the creation of the IP attaché position, state economic officers had primary responsibility for IP. But IP attachés are full-time on the issue, and they also impart their subject matter expertise, which enhances their effectiveness as focal points. Second, they established IP working groups. Several agency officials at the posts we visited in China, Thailand, and India said that the working groups provided several benefits, such as increasing coordination on training and on other activities. And third, the attachés leverage resources through joint activities. For example, the IP attachés help the foreign and commercial service efforts to assist firms by providing advice on how to avoid IP problems and answering IP-related questions. While our observations on PTO's attachés abroad are largely positive, our prior work has also demonstrated that the long-term success of overseas operations requires careful attention to human capital planning. In particular, we've observed that other agencies attempting to establish a presence abroad had to make specific efforts to ensure that they could recruit and retain sufficient personnel with both the technical as well as the cultural expertise that is essential in those posts. These considerations may be important as the Congress and the PTO make decisions about the scale and the permanence of this program. Madam Chairwoman, Ranking Member Bilbray, thank you for the opportunity to appear before the subcommittee to summarize our work. I'd be happy to answer any questions that you or other members have.
Thank you so much, Mr. Yeager. And we'll now move to our question period and proceed under the 5-minute rule. And before that, I'd like to welcome Congresswoman Carolyn Maloney to our committee. Thank you for coming and sitting in with us today. I want to delve a little deeper into what is happening, Mr. McCoy, and particularly this week in China. And we know that the government is developing regulations regarding what are being called, as you mentioned, a national indigenous innovative or innovation products. And my understanding that these regulations would in essence create preferences for Chinese vendors and eliminate U.S. information technology and intercommunication industries from China's government procurement and acquisition markets. And this proposal obviously raises multiple issues surrounding compliance with international trade laws, as well as our bilateral agreements with the Chinese government. So can you address how the Obama administration, including the USTR, has been proactive with this issue? It's very troubling to us, so let us know.
Madam Chairwoman, this is indeed a serious concern that you've identified, this indigenous innovation preference issue. Certainly it's in the interest of both the U.S. government and the Chinese government to promote innovation. There are appropriate ways to do that, and there are inappropriate ways to do that. Let's be clear, innovation is no excuse for discrimination. We are very alert to these industry concerns about China's indigenous innovation policies in a wide range of areas, including the recent announcements out of China on a procurement preference list. We are in the process of expressing our serious concerns. The interagency team in the U.S. government has sprung into action. Ambassador Huntsman has received instructions, and he and his team are in the process of raising our questions with all of the appropriate counterparts in the Chinese government. And I can assure you we will stay fully engaged and continue to follow this closely.
There has been mention that we have attachés and we have FBI and so on in our overseas embassies, and so I'm really pleased to hear that you're working through the ambassadors. I've been there, and we really need to have close scrutiny and interchange back with the administration as to how we're progressing. Okay, the 2009 Special 301 report that was mentioned highlighted the increased incidence of Internet privacy among U.S. trading partners. Some countries, such as France and Britain, have pursued legislation that would cut off Internet access for users who repeatedly are caught engaging in integral peer-to-peer file sharing. And any of you that would like to address this particular question, please feel free to do so. Do you believe that this is a potential legislative remedy to our own significant peer-to-peer file sharing problem? We'll start with you, Mr. Stoll. Thank you.
Thank you, Madam Chairman. I'm not sure that there is that type of activity would be something that the United States would want to follow. I think that there is an intent to try to take care of the issues related to piracy in many manners, but I'm not sure that removing access, I think it was in France it's a 3 strikes you're out program. I'm not sure that that would be palatable here in the United States. I think that taking many other actions to be able to reduce piracy in the United States is an important interest in all of the agencies represented here, but I'm not sure that's the right direction to go in.
Mr. Weinstein?
I would agree with that, Madam Chairwoman. As a general matter, it's my view that the technology is not the problem. It's the way in which the technology is being used that creates the problem, and I think this is no exception. In terms of criminal enforcement, we are increasingly concerned, we have been for some time, and we're continuing to be concerned about online piracy. It is perhaps the greatest emphasis of our computer crime and IP section, and in pursuing online piracy, we work closely with industry, with the Motion Picture Association of America, with the Business Software Alliance, with the Entertainment Software Association, to help identify emerging trends and to identify and prosecute the most serious online copyright thieves. We've had great successes over the last few years and are continuing to prosecuting wares groups, that is online organized groups that are engaging in piracy of software and music, focusing on the first suppliers, on the primary distributors of those materials online. We have more recently engaged in fairly aggressive investigative operations against peer-to-peer networks, particularly those using BitTorrent software. We had an operation that we called D-Elite, which resulted in 8 convictions, including the first ever conviction at trial of a high-ranking administrator of a P2P website that was distributing massive amounts of infringing copyrighted works, software, video games, music, movies, the whole works, and who got a substantial sentence. We're also trying to get to the problem at the source. Oftentimes, the multi-million-dollar online piracy scheme begins with a camcorder, someone who's taping a movie, for example, in a movie theater. And so we have aggressively worked in partnership with the MPAA and other interested partners to identify appropriate targets for camcording cases, and recently convicted, late last year, convicted a gentleman named Michael Logan here in D.C., who was viewed as perhaps the most prolific camcorder on the East Coast. So we're trying to get to the problem at all ends, both once they're on an infringing site and even at the origin, at the camcording level. I would also say that since this problem is increasingly an international one, our international work, engagement with foreign partners, is increasingly important in this area, perhaps more than any other. And the IPLEC program that I mentioned is a key component of that strategy. The fact that these sites are often hosted on servers that are located overseas presents some investigative challenges, but they're challenges that we're working very closely with our foreign partners to overcome. The fact that a person commits this kind of crime from what he thinks is the privacy of an apartment or an office somewhere in Eastern Europe, for example, or Asia, is not the safe haven that it used to be. We are working very hard with our foreign partners not only to aggressively enforce criminal laws and to take down the organizations and individuals engaging in this conduct, but we're also working to increase their capacity so that we can reduce the number of safe haven countries throughout the world for people who engage in this kind of behavior. And criminals particularly criminal organizations that engage in this type of online piracy, particularly from overseas or using overseas servers and other assets, should make no mistake about our resolve to find them and locate them and our increasing capacity to do that.
Thank you. My time is up, so I'd like to go to our most distinguished ranking member, Mr. Bilbray, for 5 minutes.
Madam Chair, and I apologize for my tardiness. Gentlemen, Mr. Stoll, you said that the American people, you didn't think the American system had the stomach to do the 3 strikes, like the British and the French. First of all, it kind of gets me nervous when we figure we don't have the intestinal fortitude of the French, but that's a different issue. You want to elaborate on why we don't have the stomach for it?
I'm not sure. Maybe I shouldn't have said don't have the stomach. I don't think that that would be the direction we would go, because their access for informational purposes would be removed completely as well. So we've got a balancing act of interests here. I think there are many mechanisms where we are able to take care of the problem related to piracy, but I'm not sure that it would probably be in the interests of our society to block access for other purposes of information exchange, education, of Internet access. So I think that that's what I'm trying to say. I think that there are mechanisms that are in place. We work with MPAA, with RIAA. There are many different things to do. I'm not sure just absolutely blocking access would be something that we would want to do.
Now, I apologize. I'm not as well versed as obviously I should be. When you say blocking access, are they talking about a national ban?
Yeah, that's what my understanding is.
Ban?
I believe that is correct.
Okay. You know, gentlemen, let me be a little blunt. I think the perception out there, and I'd ask you to either verify it or refute it, is that when it comes to intellectual piracy, China is the Somalia of the intellectual world. Is that fair to say?
If I could just make a couple of comments on that, Ranking Member Bilbray. Certainly China has some unique features that make it a special problem. One, it is an enormous exporter. It has the capability to export a wide range of goods and services, many of which have some level of intellectual property. Second, China is also a major market, has become an increasingly large market, not just for U.S. goods, but for goods from other places around the world. And so this is one of the few places around the world where you have both this enormous export capacity as well as a large internal market. So U.S. firms are understandably interested in serving that market as well as gaining protection from the kinds of exports that China does produce, both shipping here as well as to third countries.
So what you're telling me is China is at that critical location right along the major shipping lanes of intellectual property, which indicates that sounds a lot like Somalia to me.
They certainly have a unique position, whether it's in the south, the manufacturing center of the world, where they're able to produce in mass quantities and at relatively high quality, and using intellectual property in some cases that is not owned by those firms. So it does have a unique position.
Are you a diplomat? Sure sound like it. Go ahead, sir.
I'm not a diplomat either, but I've never been accused of being a diplomat. But I do think it's worth pointing out, Congressman, that sometimes some of the countries that present the greatest challenges for IP crimes generally also are the most engaged in terms of trying to address their weaknesses. So it's certainly there really is no secret, and there can't be any dispute that China is a source of a very large quantity of infringing goods, both hard goods and electronic goods. But we've enjoyed a very productive and increasingly so working relationship with Chinese law enforcement. And I think the FBI and ICE and Chinese law enforcement officials working with our prosecutors have made great strides over the last few years. So at least from a law enforcement perspective, I think China is working hard to try to address the challenges that even it identifies within its borders. One of the areas in which I think we have been effective in other parts of Asia, particularly in Southeast Asia and in Eastern Europe, through the IPLEC program that I mentioned, we've got a prosecutor who works on a day-to-day basis not only to do joint operations with law enforcement in those countries or those regions where we've got IP problems, but also to build their capacity to investigate and prosecute their own cases. And that's a program that we very much would like to see expanded, and it's our long-term goal to expand, and China would be probably first on the list of places on the globe where we think more engagement, at least on a law enforcement level, would be productive for everyone.
Well, China probably has the best capabilities of doing enforcement of anybody in the world. They probably have one of the tightest knit enforcement capabilities that anybody's ever seen on the face of the earth. So their argument for not being able to crack down really is not germane to this issue. Question as I got, though, is with at least the huge reputation of being the pirating capital, doesn't that give indications to other countries that, look, if you're big enough, if you're rich enough, if you intimidate the rest of the world, you can get away with a lot of this? Or maybe it's the other way that, look what's going on in China, why don't we try it in Monterrey, Mexico, or why don't we try it in Singapore? Singapore is kind of a tight little community, so that you might have that problem too. But questions about how that gives a potential for other parts of the country to expand, other parts of the world to expand into the pirating aspect.
I could speak to that, Mr. Ranking Member, if I could. I think it's important to bear in mind that China, in addition to being the world's leading exporter of knockoff products, is also really suffering in terms of its domestic market the consequences of really decimating markets for software, music, films, and other IP-intensive products because of inadequate respect for IPR. So there's a lesson there to other trading partners as well not to go down this path. And we have seen in the Asia-Pacific region and around the world other trading partners such as the Republic of Korea, such as Hong Kong, Taiwan, Singapore, take a different path and really look towards growing respect for IP rights as an important part of their economic growth story. And we would hope that other trading partners around the world follow that example.
Thank you, Madam Chair. I'd be very interested to know how they handle Windows 7, which was really a blatant piracy action that was going on in China.
Thank you. We'll now proceed with questioning Mr. Cuellar of Texas.
Thank you very much, Madam Chair. Mr. Weinstein, let me ask you, what are we doing to, let me start off with the Republic of Mexico, a big NAFTA country along with Canada. What are we doing to work with them internationally? Because I saw your report where you talk about domestically and the coordination that we have here, but what are we doing to work with, let's say, with the Republic of Mexico? Because now, as you know, our drug cartels are now involved, the ones in Mexico are involved in, you know, they're going into legitimate areas now, what we call legitimate businesses. So I just want to see what we're doing to work with the Mexican government.
Congressman, one of the things that we've been doing recently with Mexico is working with their officials at the border. One of the things that we do generally when we engage internationally, bilaterally that is try to identify what the particular weakness is in the enforcement regime of particular countries. And it does vary by region, and it certainly varies by country. Sometimes the problem is a lack of political will. Sometimes the problem is the political will is there, but there's corruption. Sometimes it's a lack of coordination among agencies that would be responsible for various aspects of IP enforcement. And sometimes it's some combination of the three. In Mexico, at least on the ports, what we identified as a significant weakness was a lack of coordination among agencies that would be responsible for port security. And so one of the things that we did was work aggressively at 3 of the largest ports in Mexico, including Monterrey and Veracruz, to improve the level of coordination, to teach the inspectors and the other people responsible for the security of the port how to do targeted inspections, how to identify potentially infringing goods. And at least 2 of the ports, if I recall correctly, there had never been, or at least one of them, if not 2, there had never been a seizure of infringing goods prior to our training and our engagement with them. And in the period following that, the technical assistance we provided, there were seizures through the roof at those ports, and those ports became much more effective at trying to identify infringing goods as they're moving across a border. So that's one area in which we've engaged with Mexico. It's not the only one, but it's one of the most prominent recently.
Okay. When working with our domestic partners, the different law enforcement, I know that I've heard from the U.S. Chamber, other folks saying that, you know, we got so many threats to our country that when it comes to counterfeiting and this type of piracy, that our resources are not put there. Is there anything else we can do to help our businesses to protect them from this economic loss? And whoever else wants to add to that.
Well, I'll jump in, I'll lead off briefly, and then turn it over to my colleagues. One of the things that we have done with our partners at FBI and ICE to try to improve the level of coordination and to improve our ability to be responsive to IP stakeholders is to invest a lot of time and resources in the IP coordination, the IP Rights Coordination Center, which is located in Crystal City. It's operated principally by ICE, but it has partnership from a number of different agencies, FBI and other law enforcement agencies that have some interest in IP enforcement. And it is intended to do a number of things. Number one, it provides for a pooling of intelligence from all these different agencies so that they can share intelligence and share information and make their investigations more coordinated and more effective. It's also a deconfliction center, and it's also meant to be one-stop shopping for industry. You know, we had an industry meeting there on Monday, a lunch with representatives of 29 different IP stakeholder companies or organizations. And one of the things we emphasize to them is that not only can they make referrals directly to the Justice Department, but they can make referrals to the IP Rights Coordination Center. It is meant to be a place where they can share information themselves, they can make referrals, and they can get law enforcement to respond as quickly as possible.
Yeah. And I appreciate that. I think that one-stop center, so they know who to call instead of, you know, being bounced from one place to the other place. So I appreciate that. I appreciate the work that y'all do. Mr. Yeager?
Yes, Congressman Clare. One point I'd like to make. I think your question raises a very important issue, and that is in some cases, what we find is that these are criminal networks that are operating, for example, along the border. So they may not just be involved in intellectual property crimes. There could also be money laundering. There could be illegal arms sales. There could be illegal drugs that are being traded by the same criminal networks. So I think it is important to focus not just on China, but also look, for example, at the southern border to determine whether products are being brought in by those same criminal networks that are also taking advantage of the border to make other transactions, either guns moving south or illegal drugs moving north.
Right, right. And again, from what we hear, you know, I live in Laredo, my border town, and we hear that those criminal organizations are starting to look at different ways of making money So, appreciate it. So, whatever y'all can do to protect it. Last question for Mr. McCoy. Mr. McCoy, just our Ambassador Ron Kirk, and I'll close up with this. Are we doing everything possible? I'm a big supporter. I was a big supporter of CAFTA, big supporter of the Colombia, big supporter of Panama, South Korea, and hopefully we'll have those agreements this coming year. But are we doing everything possible under those negotiations to make sure that we protect the intellectual property rights of our stakeholders?
I believe we are, Congressman. Ambassador Kirk has said repeatedly that ensuring strong IP protection is one of the top priorities for the President's trade agenda. It's something that we're working to move forward, both through the implementation of free trade agreements that are already out there, close monitoring and enforcement to make sure that those agreements are properly implemented, our trading partners deliver on their promises. Going forward, as we look toward new trade agreements, as we look to getting the trade agreements that are out there into force, we will continue that emphasis on proper implementation of IP provisions, and with efforts like the Anti-Counterfeiting Trade Agreement and the Special 301 report, we can continue to drive home that point.
Thank you very much.
Thank you, Madam Chair.
You're welcome. Ms. Chu, California.
Thank you, Madam Chair. Well, this is for any of the panelists. The GAO has identified continued weakness in global intellectual property rights protections and enforcement mechanisms, and specifically cites one challenge being the ineffective coordination of agency stakeholders charged with protection and enforcement responsibilities. From what I understand, there are 8 agencies with overlapping protection and enforcement responsibilities, and from what I can tell, there's not one single agency that leads the charge. I know that there was legislation that created the Intellectual Property Enforcement Coordinator, and this is one step forward, but that person has not yet been put into place as of now. What specific steps would you like to see the coordinator take in tackling these issues?
Yes, Ms. Chu, I can
You
summarize.
want to turn your mic on?
Yes, it's on.
Bring it real close.
You bring it closer to you.
Thank you. I think there are 3 points that we would make. We think that the legislation does address some of the prior weaknesses. I think a couple things that that we would recommend is that the new group follows the guidance regarding the key elements of a national strategy, so that the IP coordinator can create that strategy and ensure that all parts are working together. That would include not just the law enforcement, but also the policy level working together. The balance would also include working both at the firm level as well as at the industry and at the country level. And finally, I think a point that was made earlier, to the extent possible, utilize alliances with IP owners abroad, because in many cases, the leverage that the United States has can be limited, but when you also team up with some of the IP owners abroad, there could be greater success. So I think there's a couple of general points that we make in our prior statements about how this person and this new group can be effective.
Let me add from the perspective of USTR, Congresswoman, that I know that as of yesterday, Victoria Espinel, the IP Enforcement Coordinator, has just started work. I know she was burning the midnight oil last night on her first day at work because she talked with me a little bit about how we can work together. So at USTR, we're looking very much forward to teaming with her. We already work intensively with the other agencies here through interagency coordination of trade policy under the rubric of the Trade Policy Staff Committee mechanism that's been set out by Congress as a vehicle to coordinate, including on intellectual property trade policy. So we work very closely with the other agencies of the U.S. government, and we're looking forward to further enhancing that cooperative relationship under the guidance of the IP Enforcement Coordinator.
Very good. Then, Mr. Weinstein, the World Health Organization estimates that 50% of drugs worldwide are counterfeit, which translates into approximately $38 billion in loss of legitimate U.S. corporate sales each year due to the sale of these counterfeit drugs. This statistic raises great concerns for me because these are life-threatening type of issues, and there are huge ramifications to consumers who unknowingly purchase these counterfeit drugs and put themselves at risk. What methods are the Department of Justice implementing to address this problem?
Congresswoman, it's a great concern to us as well, and one of the ways in which we have tried to use our limited resources, prosecutorial resources, is to focus on intellectual property violations that are threats to public health and safety, and I can't think of one more serious than the one you just mentioned. We've prosecuted a number of cases going back several years now and continuing through the present, involving people who have produced counterfeit drugs of all types. Cancer drugs is the case I mentioned in my oral statement. There are a number of others involving Viagra and other types of medications that are mentioned in my written testimony. And what's striking about these cases is that they are international in scope, just as the online piracy cases are. In fact, in November of last year, a citizen of the Republic of the Philippines was charged here and was convicted and sentenced for participating in a conspiracy to import Viagra and Cialis and I believe other types of medication as well, and was the first person. He was extradited from Thailand. He's the first person ever extradited to the United States on a counterfeit pharmaceutical charge. We hope he will not be the last. So in that area, as well as the online piracy area we were talking about earlier, we're not stopping at the borders, and we're trying to find people who engage in this conduct wherever they are, whether they're in China or here. And speaking of China, one of the biggest cases involving counterfeit products, it's not a pharmaceutical, but it's a counterfeit product that affects health and safety, involved a national of Guinea and a U.S. citizen in the Bronx who were conspiring to import counterfeit tubes of toothpaste from China that not only didn't contain fluoride, but also contained microorganisms and in some cases contained diethylene glycol, which is an ingredient in hydraulic and brake fluid. And the co-conspirators brought in almost 83,000 tubes of this toothpaste, which had a retail value of just under $117,000. And we managed to get the importers here in the United States, and they got significant sentences. So this is an area that continues to be of concern to us. I would say, other than online piracy and counterfeiting that involves online auction sites and direct sale sites, that public health and safety continues to be the area where we try to put our greatest emphasis.
Thank you. I see my time is up.
Thank you. And we'll now proceed to Mr. Connolly of Virginia.
Thank you, Madam Chairwoman. And let me pick up, if I may, where Ms. Chu left off, Mr. Weinstein. We acknowledge that not only human pharmacological agents, but veterinarian pharmacological agents are a problem as well coming into the United States. I know the Department of Justice was involved for many years in trying to prosecute folks who were willfully violating our laws and introducing pirated antibiotics and other substances to force growth into our livestock and feed chain here in the United States. There are just lots of examples, intellectual property examples involving software, involving music and movies and all the technologies associated with them over the years. You know, it wasn't that long ago. You could go to Itaewon and Seoul, or you could go to neighborhoods in Taipei or Hong Kong and blatantly get knockoffs or infringed items at a discount. If you look at, if enforcement is everything it should be, and the estimate is accurate that we're losing about $250 million a year because of intellectual property infringements of one sort or another, the best estimate I've seen in terms of border agent seizures of pirated materials is the value is something south of $300 million. In other words, about 1% of the estimated cost of the total infringements. Doesn't that suggest that while you're not expecting everything to come through our borders, but 1% sounds pretty low in terms of our success rate at interdicting these materials or agents coming into our country?
Congressman, I can't, I wasn't smart enough to check your math, and I don't have figures myself on the amount of infringing goods, hard goods that is, that are seized at the border, but I will say as a general matter, whether you're talking about goods coming in across borders or you're talking about goods that are coming here electronically, the problem is far greater than the resources that law enforcement has available, either investigative or prosecutive resources. And I think the problem grows as more and more piracy is committed through online means. I'm an optimist by nature, but I'm also particularly optimistic because I think the people who we have conducting these investigations, leading these prosecutions, are the best trained in the world and work very hard to keep pace with and indeed to be one step ahead of the people that we're investigating. And so I think that we've got terrific people doing it, we just don't have enough of them, and the problem is of a magnitude that is far greater than our resources allow. Having said that, I think that one of the things that demonstrates is the need for us to be able to turn ourselves into force multipliers, and that is to expand capacity overseas so that our overseas partners can engage in aggressive enforcement actions within their own borders. And I'll give you just one example that I think is fairly illustrative. The IPLEC that I mentioned in Eastern Europe, you're going to begin to think I'm getting paid by every time I mention IPLECs, but our IPLEC in Eastern Europe worked with law enforcement in the Ukraine, which was trying to take down a major piracy site that was operating in the Ukraine. And they didn't know how to conduct an investigation of that type. And the IPLEC worked with them, and their technology was quite outdated. They had an outdated personal computer, and they had a dial-up internet connection. And using an outdated personal computer with a dial-up internet connection, following the guidance given to them by the one prosecutor we have over there, an investigator in the Ukraine took down the entire site. And so by engaging in trainings like that and in teaching people overseas how to make these cases themselves, not only do we have bigger, splashier, more high-impact law enforcement operations here, but we can multiply the number of people who are able to be prosecuted in the countries in which they're operating.
Thank you, and that's helpful. With respect to enforcement, there are sort of two broad aspects to this. One has to do with capability on the ground, ours and our counterparts. The other has to do, though, with political will. And I'd like the panel to address that. Candidly, we know that in some cases, including trading partners and allies of the United States, are not seized with this mission. How severe are we prepared to be, and historically, how severe have we ever been in impressing upon an ally or a trading partner or even somebody who's neither of those categories that we mean business and we're prepared to exact a price if they don't, in fact, change their behavior from the top?
I can speak to that, Congressman. I think that we need to have a strategy that proceeds on two fronts. One is to be very frank and, when appropriate, very critical of our trading partners who don't step up to the challenge. And the other front is to work in tandem with our trading partners through leadership and partnership to really get at this problem better. Because on the one hand, we have to be honest enough to call it out when the problem is bad. On the other hand, we cannot solve this global problem alone. We have to have international leadership and partnership and be working with our trading partners. And sometimes we have to be capable of walking and chewing gum, of doing both of those things at the same time with the same trading partners. There have certainly been occasions in the past when we have gone all the way to the extent of trade sanctions with trading partners who refuse to protect U.S. intellectual property. The most recent occasion was Ukraine. All of the tools of the trade arsenal are available to make progress where it's appropriate, and we're continuing to use all the tools at our disposal.
Madam Chairwoman, my time is up. And by the way, I'd ask for unanimous consent that my opening statement be entered into the record.
Without objection.
And I just want to observe before you call on Mr. Murphy that I thank Mr. McQuick for his answer. Inferentially, one could conclude from your answer some criticism of past performance on our part in terms of our consistency in strict enforcement and so conveying to other countries in the international community. Thank you.
Thank you. Mr. Murphy from Connecticut.
Thank you, Madam Chair. I want to continue to pursue the line of questioning from Mr. Connolly and other members of the committee regarding our current approach to, I guess, supply-side enforcement when it comes to pirated content on the Internet. And I was a little discouraged to hear your critique of demand-side restrictions, because I wonder about the efficacy of a strategy that effectively tries to play whack-a-mole around the world. We're talking about one guy with a computer that can move his computer, can move his location, can move the site of his hosting entity from city to city, from country to country. And I guess I don't doubt your resolve, but as we look at the trend line over the last several years, the amount of pirated content and the number of sites that are selling them are going in only one direction. And so I guess I ask this. What tools do you need that you don't have now to try to pursue this supply side enforcement policy? And how worried should I or any of us be about the ability of the people who are perpetuating these sites to just simply move to a different place or to take up residence under a different business entity, given the fact that it is so easy to just put up a new site and take one down the minute that they sniff that law enforcement is onto them?
First, Congressman, I'm not suggesting that enforcement should only be supply side or demand side. I think that given limited federal resources, we can have the greatest impact by pursuing the supply side, by getting the people who are doing exactly what you just described, who are actually the first providers of the online content that is then downloaded by people throughout the world. You can get the person who is downloading it and making a few infringing copies, but you haven't actually made an impact unless you take down the person who is obtaining it, putting it online, and making it available. To your question, what do we need? I would say that the greatest investment of resources that we have made is in this IPLEC program, because with the cost of putting one prosecutor in a foreign region or foreign country, that person can have an impact on enforcement operations, both transnational enforcement operations and enforcement operations in the countries and regions in which he's operating, that go far beyond what that one prosecutor could do working on even a very full caseload here in the United States. So it's not an inexpensive program by any means, the cost of putting a person and his family overseas for an extended. We view it as a sound investment in our ability to have a greater impact on the enforcement side, not only here but throughout the world. In terms of how concerned you be that someone has the capacity to basically pick up and move their operations, I would say there is reason to be concerned about it, but by no means are those methods of evading detection or evading capture foolproof. In fact, quite the contrary. As we have improved our relationships with our foreign partners, as we have increased our ability to share evidence and to share intelligence and to share information more quickly than we ever have before, the person who picks up his server and moves it overseas, or moves it from one country to another country overseas, is much more vulnerable than he ever has been before. And that's why, Attorney General Holder, I said that this was a high priority for him. It was Attorney General Holder actually initiated the department's first major IP initiative when he was the Deputy Attorney General back in 1999. And one of the principles of that initiative that we continue to build on today is the need to engage with our foreign partners so that we can not only have effective law enforcement against people who are operating in their countries, but so that they can be more effective in their own countries. So I think that our determination to get people wherever they are and to find their servers and to find their assets wherever they are in the world has never been greater, and our capacity to do it has never been greater.
So let me ask this, how do I square that with data showing that the amount of pirated content is greater than ever? So how do I square your enforcement capacity being greater than ever with the amount of pirated content continuing to grow?
Unfortunately, I don't think that they're inconsistent at all. I think, as I mentioned to Congressman Connolly, I think the problem is of a magnitude that is far greater than the resources that are currently available to address it. So we try to address it as intelligently and strategically as we can, both in terms of identifying what targets we should pursue in our own enforcement operations, and as I said, in terms of trying to improve the ability of our international partners. But it's largely a resource problem. I think the strategies we have are effective. I think the people we have doing it are outstanding, but there are not enough of them. So I think it's a resource issue.
Thank you, Madam Chair.
Thank you so much, and now we will call on our distinguished member from California, Ms. Jackie Spears.
Thank you, Madam Chairman. I guess this is a question for Mr. Weinstein. There's an alarming number of reported instances where information technology goods are counterfeited abroad to sell here in America. Can you speak in general terms of those nations that pose the greatest threat to our information technology vendor supply chain for counterfeiting and national security matters?
Congresswoman, I think I don't think I can speak even in the most general terms to the countries that pose the greatest threat from a national security point of view, but I'd be happy to discuss that with the folks in our National Security Division and get back to you with a more detailed answer after the hearing. What I can say is that the regions that are the greatest concern to us right now, I think, are China, obviously, as we discussed earlier, South America, and parts of Africa. And we have tried to devote resources in terms of training and technical assistance to law enforcement in South Africa, for example, in Brazil, in India, and in other parts of Southeast Asia, and again in China, to try to address that as proactively as we can. But I think that if the regions that we are the most concerned about in terms of not just online piracy, but all types of piracy would be South America and Africa and China. And as I mentioned earlier, I think those areas that present the greatest challenge are often also present the greatest opportunity. And some of the law enforcement officials in those countries tend to be the ones who are the most fully engaged with us and are just as aware as we are of the extent to which the problem flows through or arises from the region that they're operating in. So the fact that there's a great deal of piracy that involves those countries is not in any way indictment of the law enforcement officials in those countries' commitment to address it. In fact, oftentimes, as I said, those tend to be our most committed partners.
All right. Mr. Yeager, thank you for your work on the GAO reports, and I guess the ones that predated it that created the genesis of the new legislation. The one area that you keep coming back to is the area of just human capital and not necessarily committing enough human capital planning, and I guess you're speaking of the operations abroad. Could you elaborate on that some more and tell us, if you haven't already, what more we need to do?
GAO has done a number of reports, as you know, on human capital planning. We've done some for the State Department. More generally, we've done some for USAID. But in this context, I think one of the things that we learned when we traveled last summer to visit some of the key locations where intellectual property crimes are rampant is that having someone in that post who was full-time on that job, full-time on IP, someone who understood some of the technical issues related to intellectual property protection, even understanding some of the laws in those host countries, and having the ability to understand the culture. We thought that those three particular assets were extremely important. And where you had that combination, we found in our discussions with the private sector that the private sector felt very well served, and they felt that the U.S. officials could be very helpful to them in making contact, solving problems in some cases before they became a serious problem, and in some cases solving problems after it got to the point where they needed to address it with with the host government. So we certainly found great support for some of the kinds of people that were put abroad recently by the Patent and Trademark Office. But I think one of the other points that we make, and I make this in my written statement, is that you need the ability to continue to send that set of people with those skills over there. And agencies that haven't long had a foreign presence may not be that deep in terms of having people with the cultural expertise as well as the technical expertise. So that's one of the cautions that we made in the report that we recently released. So
you looked at 4 different countries.
We went to 3 countries, 4 posts. China, because of the importance of the Guangzhou area, has an IP attaché in that consulate because it's such a large producer of goods for the world.
So where else do we need to have individuals outposted that we don't presently?
Of course, it depends on the size of the program. We know that in some places in Central Europe are a significant problem. We know that South America has some, I think what USTR calls notorious trading areas. There are certainly other places in Southeast Asia where you could probably benefit from having additional personnel. But again, if the personnel don't have that unusual combination of expertise, they will not be as effective as the people that were first put in those posts.
But it would seem to me, I see my time has expired, that this should be a high priority for us if we're really going to address this issue long term. So it might behoove us to identify those other countries and make sure that there are individuals with those skills outposted. If you could provide that to us in the committee. Thank you, Madam Chair.
Thank you so much, and I would like to thank this panel for your testimony And now you will be excused so we can bring up the second panel. Thank you so very, very much.